Hi, David Fries here. I'd like to talk a little bit about how you incorporate estate planning and asset protection planning. If you've been concerned that a child or grandchild who's going to inherit from you might lose that inheritance in a divorce, there's some important things that you need to think about. Traditionally, we've used trusts in our estate planning to provide for a minor child or for a child who's growing but still doesn't have a lot of economic experience. And so they need some time and a buffer when somebody else helps them in order to develop that economic experience. So often you see a trust that would distribute at 25, would make another distribution at 30, would make another distribution at 35. Of course, the trustee in most of these trusts is permitted to make distributions at any time for reasons that the trustee thinks make sense. This gives the child or the young adult the ability to grow economically and develop a sophistication, and it gives them a buffer where they're protected and the investments can be cared for by others. However, if you're concerned about divorce or litigation, if you have a child who's a physician or a doctor or exposed to some liability exposure, it's important to consider the possibility of creating an asset protection trust. These asset protection trusts give that child, as they get older, control over the assets without giving them outright ownership. And that's what a lot of children might want as they get older. In other words, if the trust doesn't end, but instead the child becomes the trustee of their own trust at 25 or 30 or 35 years of age, then that child is protected from their creditors, from lawsuits, and from divorce. The assets in that trust are not the assets of the child. It's important in these cases for this trust to be constructed very, very carefully and very, very flexibly because it goes on for a long, long time. But this type of trust can be very, very valuable, and it is something that if the child inherits the assets, it's extremely hard for them to get the same level of protection. In most states, you cannot create a trust and put money into a trust that you've created for yourself and have it protected from your creditors. But your parents and your grandparents could create those trusts for you. So when you're doing your estate planning, be sure to ask your attorney about beneficiary controlled trusts or asset protection trusts for your heirs. It's often overlooked, and it's a very, very powerful technique. Thank you.